All right, people, we are live on another. It is Sunday. It is a Sunday evening. We have 3 hours left. 3 hours. No, sorry. 5 hours left of the weekend, at least Eastern Standard Time. Yes, I was 10 seconds late this time because I'm trying to adjust my camera. Now, people, if my camera starts to slowly sag over the course of this stream, just want everyone to appreciate this is what my camera system looks like. So that is what I'm looking at. It's taped to the wall, and I think it's starting to slowly untape and it sags down. So if you start seeing those lights sag more than they should, let me know and I will adjust the camera. So how is everybody doing? What I love, I love this in the sense that I never thought I would be doing live streams that people would actually like that would become part of their week. And it's a very weird thing because it's the ikigai principle. When you find what you are good at, what the world needs, what you love, and it all meets. And I never thought it would be a live stream on a Sunday night with a lawyer who I only met through the beauty of the internet, and people would look forward to it. And it's amazing. It's encouraging. It's humbling, and it's beautiful. So here we are on another Sunday evening, Viva Barnes live stream. We've got so many things on the menu. Robert is like that teacher in high school or university, probably more like university, who just dumps a ton of homework on you and doesn't think twice about it. And so Robert's been sending me these links, and I've been trying to keep up, and I'm doing my best, but we've got a lot on the menu. On the menu this evening, let me just see if everything is good here. Everything looks good. Audio's good. Mic check 1, 2. On the menu, we're going to talk about Lin Wood's drama, potential disbarment, the complaint in Georgia against him. We're going to talk about big tech seemingly working hand in hand at the direction almost of the government. What impact might that have on pending lawsuits, on lawsuits that have yet to be filed, the legal impact? I think we're going to talk about Amy Cooper briefly. We're going to talk about Rittenhouse updates, if there are any, and a ton of other stuff. So that's what's on the menu, by and large. Let me just see now. I see my first super chat, second super chat, which is the good time. Is the Paul joke over? The Paul joke will never be over. And my goodness, I'm going to share. Did I share it in community on YouTube? I shared it on Twitter. It came from locals. It is the most glorious meme ever because it actually makes me happy to look at. And it's so well done. I'm going to have to share it if I can find it. So let me just pull up a few super chats so I can talk about this and give the first disclaimers. You're better than 60 minutes and use this to put towards a new camera. The camera's good. I just need a good mount on the wall. The problem is my kid uses this for Zoom classes. So in order to make it easy to remove from the wall, I've just used double-sided duct tape or tape, whatever. Thank you very much, David, for the chat. Have you looked at Bitcoin or other crypto? Not talking about it because I'm not going to experience what Eric Hundley experienced. Actually, good intro for that. Let me just get up the other super chat if I can find it. And I cannot, which I'm going to read it. No, I'm sorry, I can't find it. What was the other one here? Oh, gosh. Hold on a second. I'm losing control of my fingers on the thing. I got that. Here we go. This one. Time for my weekly hit of copium. I have really been needing a hit for this week. I don't know what copium is, but thank you very much. So first disclaimer. Thank you all for the super chats. I do my best to get to them. I'm going to miss some. If it's going to miff you, if I do not read your super chat out loud or bring it up in as much as possible, don't give it. It's not to sound curt or crass. I don't like people feeling bad. It's to show support for the channel. And I do my best, but I will not be able to get all of them up. So if it's going to miff you, don't give it. Second thing, YouTube takes 30% of super chats. So if that irks you, and I would understand if it does, there are other ways to support the channel. Robert and I split these super chats, but there's other ways to support us if you don't want to feed the beast in that sense. Third thing, nothing legal advice in here whatsoever, yada, yada, yada. Okay. Eric Hundley, I think it was last week. It was last week. He had his channel. Within a 1 minute, he got 3 emails saying that his live stream breached the terms of service, his live stream has been taken down, and his channel has been terminated. At 10:46, 3 emails back to back to back. And he was rightly upset, rightly, I won't say distraught, because he had me to talk him through it and to make sure that he understood it was obviously an algorithmic glitch that, they got a warning, they sent whatever, and they got, it's a machine. It was not the politicized type of soft censorship that we've seen on other channels, which is why it's like, it wasn't wrongthink. It wasn't Eric upsetting the wrong people. It was just clearly he talked about something that YouTube didn't like, which might be one issue. And they gave him a warning, take down the stream, and channel termination in 1 minute. Long story short, his channel has been reinstated. All the content has been reinstated, and he received confirmation that his channel is in good standing, no strikes, no nothing, thus confirming it was an absolute glitch. So that's the good news of the week. So let me see what else. That's not my rant, though, while we wait for Robert to come. My rant for the week, and we're going to get there, Canadian politics. Give Popcorn Gate a mention and enlighten your non-Quebec friends. Popcorn Gate? I'm nervous about saying something that I don't know means something worse than what it means. It sounds like my 12-year-old daughter has become a fan. Viva watching with me. She wants to go to law school now. Thanks to you. Goodbye, vacation home. Thanks, guys. First of all, I love that kids are watching. It's one of the reasons why I do keep the channel clean, is because I know my kids have friends at school. When I see them, they watch the channel, and I don't want to be a bad influence in the sense of swearing and cussing and, that type of stuff. I may be a bad influence in that I might, teach kids to question authority and have a little ODD, oppositional defiance disorder, which in adulthood is actually a good thing. As a child, it's also a good thing, but can get you kicked out of high schools. No pun intended. No joke. Don't read this out loud. You're great. Too late. Thank you very much, Wizard. So let me get to the one thing that I wanted to get to before we did that. The U.S. Consensus Bureau was working with big tech to censor anti-census content in 2020. It all comes out eventually. Sunlight is the greatest disinfectant, and I think it was it Buddha who said, 2 things cannot long be hidden. 3 things cannot long be hidden: the sun, the moon, and the truth. Still myth from last time, but I love you guys. Mr. Frobot, I apologize if that's not a joke, but I get the feeling it might have been a joke. Sorry, completely. Matt Jackson, I'm not even going to read it, but yeah. So apparently the problem that Eric had is common to other types of digital money channels. Okay, so here comes the rant, people. Yesterday's video, an MPP from Ontario, a member of provincial parliament, proposed a bill, which obviously would never become law in a million years, that politicians should reduce their income to the CERB, which is the Canadian Emergency Response Benefit Program. They call it a benefit program, to actually be downgraded financially to receive $2,000 a month while you're told you can't work and have your business shut down. But they call it a benefit. It's a nice euphemism. The bill was to make a point to reduce parliamentary salaries to CERB levels, to COVID benefit levels, pending a resolution of the lockdown, the shutdowns, the shutting down small businesses, non-essential businesses. The lawyer politician who proposed it, Roman Baber, put it forward. It got shut down, obviously. A counter motion was proposed by another politician. I don't know his name offhand, and even if I did, I wouldn't mention it. I'm not trying to. Guy's a jerk and did a stupid thing that's an embarrassing thing, makes everyone look bad. Proposed a counter motion to reduce only Baber's salary to the $500 a week, $2,000 a month CERB levels. That motion received unanimous consent among the politicians there. So, there's one jerk politician who's responsible for proposing something obscene. Everyone who voted for that is equally guilty. Baber, from his tweets on the issue, said, he put out 3 tweets on Twitter, said he didn't even vote. He abstained because he didn't want to be in a conflict of interest to vote on a bill, a motion that related to his own salary. All of that to say that, the video that I put out yesterday is, if these politicians were experiencing the consequences of the measures that they are imposing on others, I have a sneaking suspicion they would find alternative proposals, alternative measures to deal with this health crisis. I have a sneaking suspicion that if they lived by the measures that they proposed, they would find other solutions, they would find other measures, and this would probably be fast-tracked a lot faster. Canada seems to be back of the line for vaccine availability. And without getting into the politics of why that might be, whatever. Bottom line, if only these politicians would suffer not suffer because they should be suffering. It's a benefit. If only they received the benefits that they were giving to others, they might find alternative methods of dealing with this that are not draconian and that are not destroying the very fabric of the society they purport to want to protect. So watch that video. It was up yesterday, and it's a good one if I do say so myself. I see Robert in the house, so I'm going to read Cleopatra. Hi, David and Robert. I won't be here. Out for dinner. Out for dinner? What is this? You go out to a place where strangers... I'm stealing Dave Rubin's joke. He was in Florida, and he says, I'm at this place where strangers cook food for you and bring it to you. We're still on curfew in Quebec. Let me finish reading. I won't be here. Out for dinner. Just wanted to show support and say I'm devastated that the borders between Canada and the U.S. were closed again today. Of course. For how long now? It's been a year. Who knows? Have a good night, everyone, and thank you, Viva Barnes. Thank you very much, Cleopatra. And, I was just on a Zoom call with my family in the States. It's been a year and 2 months, a year and 1 month since my sister and brother and their husbands and wives and daughters and children, my parents' grandkids have seen them. It's totally normal. It's totally normal. Okay. Let me see here. Do one more before we bring on the Barnes. I can't. I'm sorry. So let me see. There was Cleopatra. There was an H. High-Tech Redneck, who's a new member. If I can bring up your chat, I will, but I can see it on my screen. Comment. Confirmation bias and polarization is the foundation of search engine algorithms. Great when looking for stuff. Total opposite of what we need in social media. Very good point. Let me see if I can't bring up High-Tech. I cannot bring up your chat because it's off my screen, but I read it, and it's a good point. With that said, Robert, I wore my nice shirt tonight, and it matches your tie. We did not coordinate, everybody. Robert, how are you doing tonight?
Good.
Okay, so we've got a lot on the menu, and it's going to be an intense night. We'll get to some questions because I know that people have a lot of questions. Unleash the Robert or we riot. That is to say, okay, I have jokes that I can't make with that one. Viva Barnes is like peanut butter and chocolate, so good. All right, that is as ringing an endorsement as we can possibly get. First of all, you look like you're in Nevada.
Oh yeah, still in Vegas.
Okay, and now let's do this at the beginning. Everyone always asks for it at some point randomly throughout the stream. Let's get 2 book recommendations and 1 movie recommendation before we get into our random reference of a movie and a book.
Yes, I was on the same page. So the proof of Carl Jung's collective unconsciousness, another topic for another day. But right behind me here, there is a book I carried around with me when I was 12 years old. I had 2 books that I carried around with me a few months after my father passed away. It was 2 books that really kind of inspired me. And there was one other person who inspired me, which will be the film reference. But the 2 books, one was Donald Trump's Art of the Deal, which I still remember certain phrases from to this day. And the other was To Seek a Newer World by Robert Kennedy, his 1968 campaign text. It's really, there's a lot of genius in it. And the world may have gone a very, very different direction had he not been assassinated. The other book behind me here is Farewell to Justice. It's Jim Garrison's efforts to try to get some accountability for the assassination of John Kennedy, and his discussions about what took place in that case, later largely remade and recreated in Oliver Stone's film, JFK. But the cinematic reference is to the new MLK Files release. It's an early release on Amazon Prime and some other locations. That gets into all of the reasons, the motivations, the scope, and the scale of the taping of the other person who was my hero at the time, still my favorite American of all time, which is Martin Luther King. When I was a little kid, I spent all my saved up money to buy all the tapes of his speeches. And that was back when he had cassette tapes. And your kids probably wouldn't even know what those things are. I'd be like, what? But I used to listen to all of them over and over again. And I was in Memphis, Tennessee, when they commemorated the Lorraine Motel being converted into a civil rights museum as a teenager, which was a great experience. Got to see Jesse Jackson speak in the same church that was Martin Luther King's last great speech about how he'd been to the mountaintop and seen the promised land. And there's two good literary references and actually two cinematic references.
Fantastic. And I don't want to get into the Robert F. Kennedy, although the segue might have been there. We'll get into that one in a bit. My one book reference, I've been thinking about it a lot lately. It's John Ronson's So You've Been Publicly Shamed, in light of a couple of things that happened this week with this week with Ted Cruz, last week with Gina Carano. It's an amazing book to read, and I've been actually listening to it with the family because I think the Justine Sacco story, for anybody who doesn't know, is a lesson for everybody. I don't know that people are going to learn the right lesson from it, but that's my insightful book that I don't read or listen to that many books, but that's one of them.
That's a good transition to maybe a early topic. That'll be a quick topic because I can't get into much detail, but yeah, Amy Cooper case would fit into that storyline too.
So that is a good one because we'll do it. We'll do Amy Cooper. Everybody knows the story. I put out a video on it this week. I've done 3 videos on it. One of those examples of someone who reacts badly to, we can only qualify it. She reacted badly. Now, some people are going to say maliciously racist, could have gotten, someone in big trouble, possibly hurt by the police for the call-in. Others are going to say, my personal belief is that she's clearly suffering from some anxiety disorder. Call me, I'm not a doctor, I'm not diagnosing, it's just my opinion. Do I think that in her own mind that she was terrified? I think she was out of her mind in terms of being terrified. Whether or not it was rational is a totally separate issue. And, when it comes to subjective elements of fear, we can compare it to AOC's subjective elements of fear, given, what she explained was her historical background. We can draw some analogies. So we all know what happened with Amy Cooper. The charges were dismissed against her. And now there's a discussion online because Tim Pool and others are saying, that this was a Jussie and Nate Brody. This was sort of a Jussie Smollett pretrial diversion type, conditioning the dismissal on her attending psychotherapy. They literally called it psychoeducation. I think it was called psychotherapy. Someone might correct me in the chat. Psychotherapy or psychoeducation, where she attended 5 classes. After she completed the 5 classes, they dismissed the charges.
So there's a range of confusion out there. The short answer is Nate and other people are wrong. This was not an ACD case. This was ACD in New York is a version. All states have it. They have some version of diversion agreements.
What does ACD stand for?
So ACD, and this is why Nate should have known this was not this. ACD is adjournment contemplating dismissal. So what happens in New York, their method of diversion, only applicable to certain charges, is you agree to adjourn the case, usually for at least 6 months, often a year, in which you have to do certain things in that 6 months to a year. And then they will dismiss the case at the end of that time frame. That was not this. This was straight dismissal. There was no adjournment in contemplation of dismissal. There was no diversion agreement. There was no plea agreement. This was flat out dismissal with prejudice, which is legally the same, frankly, stronger than an acquittal at trial, because it's not just proof beyond a reasonable doubt. It's that there isn't probable cause to go forward. So that's part one. Wasn't a diversion agreement, was not ACD, was not a plea deal or anything of the sort. She is legally innocent, and that's the legal determination of the effect of that outcome. The second part is that some of this misunderstanding is bred by the media not covering certain parts of that hearing. Now, I'm not going to get into all the details of her story. That's going to be coming out with a media source that was given an exclusive. What I will say is what was on the court record, which somehow the media just didn't hear. Either that or they had sudden paralysis of their hands and they just couldn't type it into the report, which was the prosecutor put on the record the real reason for the dismissal. Didn't put it this way for obvious reasons. Everybody agreed to lower the temperature. And so the goal was for the prosecution needed a dismissal that would lower the temperature in New York, because in case people don't know, they had more protests this past week. So, and for people who don't know the timing of it, Amy Cooper incident happens before George Floyd, before everything went crazy this summer. So her case sort of gets caught up in that maelstrom, and the goal, and she was happy to do anything that would help turn down the temperatures. What she did was not, Tim Pool is also wrong. It was not some re-education thing or anything. I understand why people are concerned about that. That's not what this was. This was a voluntary counseling session that provided further proof of her innocence and helped the prosecutor turn down the temperature in New York. So it was her accommodating that. She's already apologized, regretted what took place. But what the prosecutor put on the record that nobody in the press, and there was a bunch of them there live, reported on, was that, in fact, the only actual report made to police by Amy Cooper that she initiated was to the police at the scene. That there's this big myth that she never talked to the police, that she left, that he could have been swatted. All false, 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 false. She waited for the police to arrive, explained to them that she wasn't sure what his motivations were, that she took the blame, that she didn't have the dog on the leash, and she apologized for that. Didn't want anything bad to happen to him, period. Took responsibility like there were people second guessing her apology. She took responsibility long before this became viral at all. So now I don't think, and this should have been the clue to people out there. Clue number one should have been that the person who is the alleged victim, Christian Cooper, kept saying it's wrong for her to be fired. It's wrong for her to receive threats, and I don't support the criminal prosecution. That should have been a clue that he knew something about the case, since he was the witness to it, that other people in the media weren't telling. And instead, people had to come up with like crazy explanations for why he was doing this. Maybe it's because he knew it was the wrong outcome, because there was mutual accountability for that, for an old bird watcher, dog walker dispute in New York. Central Park goes back half a century, including passing criminal laws that prohibit things like trying to get people's dogs that are off leash away from them to help mitigate these kind of things. So that was part one. And then part two is look at who the prosecutor and the police investigators assigned to this case were. You had the prosecutor who put Harvey Weinstein in prison, one of the top prosecutor in New York, one of the top prosecutors in the entire world assigned to her case, and 3 detectives from the cold case division of the New York Police Department, meaning you've got 3 of the top detectives in the world assigned to her case. They all agree, along with Christian Cooper, that the appropriate outcome in this case is complete dismissal. Maybe the media should have said, maybe we got something wrong about this case. And it just fits my broader story, which I said back at the time. We should, in this viral culture that we try to take, we combine Jerry Springer with social media. The rush to judgment goes back to Mike Covington case. That if we take 90 seconds of any of our lives and we put it on a social media clip, completely stripped of the context of who we are, stripped of the context of what happened before that video started being recorded, which Christian Cooper, to his credit, put on the record, but the media just decided not to cover that part of it and sometimes lie about that part of it. And what happened afterwards, which the media again just chose to omit, who of us would not be harshly judged? Anybody with 90 seconds of the worst time of their life put on social media, stripped of all context, both in terms of temporal context and in terms of our individual life, can be made to look terrible. We should not rush to judgment. It's my favorite principle of Elvis Presley. Don't judge a man until you walk a mile in his shoes. And by golly, let's get out of the habit of judging people based on 90-second social media clicks.
So 2 things, because I agree with that. There's no question. And we've talked about that a bunch before. You can unleash a torrent to destroy a person. And first of all, even if it's warranted, it's not necessarily how things are done civilly and in a manner that, is susceptible of civil unity. Second thing is sometimes it doesn't happen fairly. So first question though, there was, Nate mentioned it. There was a postponement of the hearing in January to February pending the dismissal. And so people think that was to complete the classes as the quid pro quo for the dismissal.
Yeah, it wasn't a quid pro quo for the dismissal. And it was the way an ACD works is you go on the record and you adjourn the proceeding for at least 6 months to 1 year out to do certain things. That never happened. So the proceedings were adjourned a couple of times to accommodate what the prosecutor needed in terms of certain public representations, which was fine. The goal was to turn down the temperatures. She was happy to participate in the class. It was not a re-education course or anything like that. She's from a small town in Canada. The nature of the exact politically correct terminology to use in a potential contact or conversation with police or anyone else is not something she was well versed in or grew up on. And I still have problems with some of the, not only just the inferences that people raise. People rush to judge someone based on one word that was, in my view, a harsh rush to judgment that the facts would not ultimately vindicate or validate. But putting that aside, do we really want to start criminalizing 911 calls and making sure every single thing you say fits within a certain category? And someone could look into the New York laws and see whether they actually do criminalize 911 calls. So this case would have been dismissed sooner or later, regardless of any or taking any courses or anything else. That was always the remedy. The goal was to have a remedy that accommodated the public interest in turning down the temperature. That's all that was.
Well, first of all, some people might want to criminalize anything they can so they can distract from other things. I mean, the emphasis politically and resource-wise that was put on this case, given what's going on in New York and the 100% increase in certain violent crimes, it's obvious it's a distraction. It's a theater, and the politicians play into it. And there's no doubt whether or not there's something underlying in this case that warranted it in the first place. That'll be up for debate. Now, the flip side, though, people are going to see this, and I'm sure that it was sort of a political jostling on both sides. The prosecutor, nobody was forcing her to go follow these classes, but it was sort of unwritten. They knew they'll be much nicer with her if she does it. And so, though she's not being compelled by ACD or pretrial diversion, the equivalent, she does it, and they're going to go nice and tone it down. But some people are still going to see that as a pressure tactic to compel quite literally re-education schools to get people to be woke. And that's the way
people are concerned about it. That just isn't this case. So it's like people that are critical of ACD or restorative justice programs. That's not this case. People that are concerned about the weaponization of the criminalized process to require re-education. That's not this case. A lot of people keep wanting to cram this case into their preordained political narrative. It just doesn't fit that. The closest narrative this case fits is the Covington case, a rush to judgment about someone that was wrong, and that if once all the facts were known, everybody agreed, all the participants, prosecutor, police, the alleged victim, all agreed she shouldn't be fired, and they all agreed that dismissal with prejudice is the remedy. And keeping temperatures cool in New York, she was happy to do. Now, knowing that some people are going to misinterpret what she did, but her goal was to end this proceeding, but also to make it clear she never had any malevolent or malicious intent towards anyone. And I can tell people, from a focus group and other perspective, most people who would got all the facts were going to vote not guilty, period. But also would also have they would have reacted stronger than she did, quite frankly, given the statements that he made. Well, I don't think it's a good idea. One of the problems I had with all this is it a good idea to be encouraging men to approach women alone in isolated places in the park and saying things like, I'm going to do what I'm going to do and you're not going to like it? I think that's not a thing we should encourage in society. I think to his credit, Christian Cooper recognized that. Part of the reason he took accountability in his own way by saying, quit harassing her, quit threatening her, don't get her fired, don't prosecute her. So some people interpreted my social media statement to be something about him. It was not. It's about members of the media and some other institutions and professional societies and employers and other people who've been lying about Amy Cooper now for almost a year. And some of them, they're going to be getting the correction letters soon. And once her whole story is known, I think a lot of people are really going to regret the rush to judgment they made about it.
All right, and I want to say one other thing about Nate Brody, who put out a video yesterday and has been taking flack because in his video, he says this is similar to Jussie Smollett. Both were charged with filing a false police report. And I've been reading the comments on his video, and people are saying this is totally different. Jussie Smollett's scum of, whatever they're saying about him. This Amy Cooper's innocent. Context is different. The bottom line, to be fair to Nate, and this is where, focusing on the relevant facts is what's important. They're similar in that both were charged with filing a false police report, among other things. I think Smollett had a few more charges in his indictment. So that was the similarity. They were both charged with filing a false police report. The facts are different and the culpability is far different. And then Nate's other issue was that, and the basis for the dismissal was similar. So Roberts cleared up, or at least presented his side as to why this was not a pretrial diversion, ACD type dismissal. Question of fact, and you'll assess whose facts you're going to go with. But Nate was not saying that the level of culpability between Amy Cooper and Jussie Smollett was the same, only that the charges were the same and his understanding of the dismissal was analogous. So we'll see where this goes. It's interesting. Yes, people should stop jumping on these bandwagons, taking people they know nothing about, even if they think they have an opinion of it. It's like it's the Justine Sacco all over again, where I genuinely think people do it and people pile on, knowing they know darn well that they don't truly believe what they're saying, but it makes them feel so good and look so virtuous on social media to judge others this unforgiving.
Personalities on The View, some other people that they keep repeating false statements, and at some point there'll be consequences to that. Just because their ABC reporter chose not to report what the prosecutor put on the record about Amy Cooper making honest, direct statements to the police officers when they arrived and clearing everything up from the get-go, is not an excuse for members of The View to keep getting the facts wrong. So there's a lot of people that keep getting the facts wrong about this, and it's because they're more committed to what they wanted to believe than the truth. But when a top prosecutor and 3 top police officers and the alleged victim all agree that dismissal with prejudice is the appropriate remedy, that should be a clue. But we'll see how many of them get that.
And why they would even be there in the first place is a separate issue. And those who omit the relevant fact of what Christian Cooper admitted to saying, if you're going to do what you want to do, I'm going to do what I want to do, and you're not going to like it, come here, doggy. Half the people omit that.
That just is. I mean, I'm not criticizing him, but I think he acknowledged this by implicitly. He had no reason to be real explicit about it, but he's the one who put that up on Facebook from the get-go, that he said that. He admitted it, to his credit. And secondly, he's the one that kept saying this is the wrong reaction. And yet the media didn't want to hear that. And because they wanted the fake news version of the event, the social media version of the event that wasn't true. And especially the willingness of human beings to rush to judgment on someone they've never met, that they do not know, based on a 90-second video clip out of context, is a bad habit for society. And it's one that hopefully that this case will help deter in the future. It was not good behavior on the public's reaction, was some of the worst reaction in all of this.
So all that to say, everybody, go read John Ronson's So You've Been Publicly Shamed, and you might view these types of pile-ons with a little more sympathy in the future if you were inclined to get involved in the first place. Gilded Link says, hey, Viva Barnes, any chance I can convince you to mirror your content over to Library or Odyssey? They have a channel sync program I can't figure out. All of my stuff is on Rumble as well, and I'm fairly certain it's on BitChute. So and Rumble is good, like I've explained, because it's good for creators, because it's monetized, and it allows people to get remuneration for the work that they put in. Okay, the second thing, that's done with. That's it for Amy Cooper. We'll see.
There'll be more big updates coming with a story that's coming, so that there are people get all the details. And there's some people that may have legal remedy coming if they keep lying about her. So but that's not concerned Christian Cooper. I'm talking about institutions. And so we'll see. But the only other sort of temporal update was on the Rittenhouse case. And that's just that all the civil cases against him have now been dismissed, and dismissed with prejudice. Like the Amy Cooper criminal case, dismissed with prejudice, dismissed so it can't come back. So it's done. So the no civil suits are pending now against Kyle Rittenhouse.
Now, in the Rittenhouse cases, the suits that have been dismissed, was it a voluntary dismissal by the plaintiffs, or was it by a judge?
It wasn't by settlement. It wasn't by agreement. There was some speculation on that. That was not the case. It was to avoid a motion to dismiss that could be brought, that could lead to fees and other things. So is my interpretation of it. But yes, it was brought by the plaintiffs. They requested dismissal with prejudice, and that result. And just for those people who don't know, dismissal with prejudice means you can't bring back the case or the claim. Dismissal without prejudice means you can. You just don't get the benefit of statute of limitations and things like that. But that's the difference between the two. But all the civil claims against, now the criminal charge is still pending. The civil case, all the criminal charges still pending. And I put up on our locals page, vivabarneslaw.locals.com, which has some great memes. Shout out to Talix, who makes beautiful memes on our behalf. The rock star one is I think it's your favorite. It's my favorite so far.
It is. I'm gonna post it in community on YouTube. It's seamless. So the first thing is it's seamless. I look at it. It looks like we were actually doing this, and the detail, the tattoos I had on my arm. It said, now I forget what it said, but it had a Canadian flag, and then it said something Viva maybe in the background. It's got Groucho.
It had like free speech in the background. It had We the People on the guitar. Yeah, it was on the locals page, I put a link to the fundraising for Kyle Rittenhouse. That's for his security primarily right now. Also goes to his legal defense, but right now that the priority is his security and safety of him and his family. The threats they're under is the worst I've ever witnessed. Yeah, it's tremendous. So anybody, you could see the links there. Robert does share it on Twitter as well. There's a paywall for certain posts on locals, but I think we'll get that on Twitter as well. What I was about to say, just on the voluntary dismissal, so that if it's not totally clear to people, the plaintiff can withdraw their pleadings with the consent of the defendant. I presume if the defendant in certain cases wants to be a pain in the neck, they could oppose the voluntary dismissal with prejudice and go for some form of costs or fees, but typically they might agree to it just to resolve it at an early stage. Yeah, 99% of the time, you're not going to drag that out. When you get a dismissal with prejudice, you get it and move on. Okay, so that's the case of the civil suits, which, interestingly enough, incidentally, they were for the damages resulting from the incident. Correct? They were not defamation suits. That's correct. Bearing in mind, everybody, civil, the burden of proof is lesser than criminal, and these individuals who had sued for civil damages are now saying, we don't think we have a case on the preponderance of the evidence. Take it one step to criminal now. The prosecution is going to have to prove not preponderance of evidence, but beyond a reasonable doubt. So in theory, I guess the idea is that this is an indication as to where things, legally speaking, might go or should go. It's kind of like the Amy Cooper case. A full investigation will reveal even more facts than people know that prove Kyle Rittenhouse's innocence. And that's in process. And the only reason why that's even possible is because people have contributed to his defense and continue to. Only reason he's safe, because whole family, I mean, he comes from a poor family, a working poor family. I mean, his mom was busy working 100-hour work weeks. That's the kind of work week she's used to. And what she said is that she's very thankful to everyone who's helped out. The way she put it is she's not used to people fighting for people like her. And so it's an important case, critical case. And I'm going to continue to deal with the prosecutor the way I feel about him, which is he's politically weaponizing the case and lying about Kyle Rittenhouse to try to create a legal lynching. And that's why it's only the defense of the public helping fund his security, helping fund these investigations that are revealing more and more facts. Remember, there were thousands of people there. There's hundreds of videos. There's thousands of potential witnesses. This is a massive, massive effort. I mean, it's almost unparalleled and unprecedented what's going on and what he has to do to defend himself in this case. But there's going to be some shocking facts that come out that are even more into his acquittal than the facts that are already known. Okay, that's an interesting, I mean, to be continued for sure. And because Robert, for everybody who's out there, is somewhat involved, there are some limitations on what he can. I'm representing him in the court of public opinion in all civil matters, and assisting strategically in the helping gather information to support his criminal defense. Have not yet appeared in the criminal defense case, may at some point in the future. All right, and that is that. I know a lot of people in our chat and on our channel are going to be very happy with that. Now, I'm not sure that I want to get into this, Robert, because I'm not sure that you should, but it might be a good segue into all the Lin Wood problems. I think it's I still have, my criticisms of Lin are pretty public. I'm not a big fan of how they're weaponizing the Pro Hoc Vice process and the state bar process, though I'm not sure Lin is handling his defense in the most effective way either. So for everybody, I guess the overview is that Lin Wood is now facing a number of ethical complaints. I think the one where he's been filed, I think it's the only one that's been filed thus far, is in Georgia. I don't know if they filed in New York yet, but they have filed to revoke his Pro Hoc Vice in New York. They may challenge if he tries to appear Pro Hoc Vice on behalf of Sidney Powell in D.C. And they have brought a very large ethics complaint of some sort against him. He chose to publish it, which was interesting, but because otherwise those are confidential proceedings. But he published it. From his only licensure is from as far as I know, is from the state of Georgia, and he faces a very large ethics complaint there. And he was originally, they asked him to take a mental health exam. He refused. But the controversial part that's getting him into some trouble
is his
is
crowdsourcing.
Yeah, go ahead.
Okay, so for those of you who don't know, it's look, I recommend against it all the time because it can be misconstrued and it can go badly. But so for everyone who doesn't know, he's facing an ethical complaint in Georgia. He publicly went out, and if anybody wants more detailed analysis on this, go check out Nick Rekieta, who's been covering this left, right, and center. Nick Rekieta is the Lin Wood complaint lawsuits channel. Although we do it once a week, Rekieta's on it sometimes more than once a day. So he has the ethical complaint in Georgia. He says now publicly, he goes on Telegram, I think it is, and says, they're going to go after me and test my fitness to stand as an attorney. I'm going to go after them and test their fitness to judge me. So all of you, and he's got a legion of followers, gather information about all these people who wish to judge me, and let's use that against them. And from what I understand, also the biggest no-no you can possibly do, he posted addresses of the people on the board. So that is, I've got not just it. You could feed them, yes. So so he did that, and now I don't know if it went bad, because he's got some dedicated fans and some dedicated followers, and people don't necessarily know what lines are not to be crossed, even in the context of a vigorous defense of an ethical complaint. But that's what he did. He basically crowdsourced to get damaging information on the people who are trying to get him disbarred. And then he published his complaint, which is a separate issue. But I mean, yeah, Robert, take it from there.
So that was used against him in the New York proceedings, as well as everything he did leading up to and on January 6th, where in the New York proceedings, there he's representing someone suing Joy Reid of MSNBC. I didn't write that. Somebody hacked my emails, Joy Reid. The sort of the same defense as the C-SPAN person. You can look into that and see whether you find it credible or not. But putting that aside, and she clearly seemed to me to have libeled someone, and the Second Circuit reinstated that case. But they're using the combination of what happened leading up to January 6th to try to get his pro hoc vice revoked, the fact that the Delaware court revoked it, the fact that various sanctions motions are pending against him, and now they got to add to it the Georgia complaint because he decided to publish it, so that allowed them to include all of that in it, and then the fact that how he responded. And I think the problem is, my own view is, you're entitled to crowdsource information about, this has been contested in the criminal context. So there are people that will crowdsource information about witnesses, and you have to be careful how you do it. But the idea that you can't investigate whether someone's lying about you by crowdsourcing that has constitutional ramifications. So but the way he did it is going to probably be used against him, and it's already being used against him. And I think my guess is it'll be very hard if he's still licensed within a year. So I think that's just, and I've been saying all along, even though I've been a critic of Lin for quite some time, and for good cause, I believe. But the other point I've been making to him and Sidney Powell, and to some degree Rudy Giuliani, was that everything related to what they were doing was one big trap that was set up to not only discredit the election suits, but also to discredit them and destroy them. And unfortunately, they just never listened. Particularly Lin, and now he's facing what he's facing. I think there is these are not. I agree with Nick Rekieta that the point of the licensure limitations and restrictions and suspensions and punishments should be predicated upon a client complaint, maybe a court complaint about something you did in the proceedings, but that would be it. It should not come from political opponents and political adversaries. Like we're seeing in all the other attempts to cancel lawyers, cancel their jobs, cancel their clients, cancel their professorships, as you talked about this week. This does appear to be weaponizing the state bar and trying to set a precedent to go after political opponents, which they have done historically, but not to this degree of public attention. But on the flip side, I don't think Wood is helping himself with some of his defense tactics.
No, there's no question that what he did, if people want to call things dog whistles, some are easier to be called dog whistles than others. And going out on social media, on Telegram, and asking people, giving addresses is just, it's not ever going to be well received, and it could go even more serious than just being used against you. I mean, it can just lead to other complaints, of ethical and criminal nature. But First of all, actually, that's a good. I just brought this up because it's nice. I watch your videos and streams a lot, but never guessed common law would ever hit me close to home. Recently, I learned my former classmate was extradited from UK and now waits for plea hearing in the US. I'm glad I've learned a bit from you both and understand what happened. Thank you very much. But getting to the actual complaint against Lin, because I've been reading it. First of all, I think it's terrible to weaponize the ethics body against lawyers you don't like. Some of the things that I would have criticism against some of Lin's tweets, accusations against Chief Justice in particular and VP. I know that these might be protected speech in everyday citizens, but when we sign up to be members of a bar, we do to some extent agree that we're going to suppress our otherwise inalienable freedom of speech somewhat. You have to show deference to the court, whereas a citizen will not get disbarred for telling a judge to go F themselves, but if a lawyer does it, you will. And so it's a limitation of free speech, but it's one you sign on to when you sign on to the practice. So some of the tweets, I think, were crossed the line. Some of the things that they're going after him for, though, seem like they are retrying lost cases in an ethics complaint, which to me is having a second trial based on insufficient evidence in a context that doesn't allow for a meaningful trial in the first place. They're going after his conduct in the suits. They're going after whether or not he disclosed, whether or not he served documents properly, whether or not he filed a court order that he was seeking to have obtained, a draft of the court order. In one of the cases, they're saying that he signed off on a lawsuit where the plaintiff said they don't have the right to represent me, and I never agreed to that. So in that particular example, I forget what the guy's name is, if he files a complaint, that would be a legitimate one. But in all the other stuff where they're just reassessing how he conducted the file and the probative value of the evidence that he filed, that doesn't seem to me, barring the most egregious cases of lying to the court, to be what the ethics panel should be used for. So, I mean, that's what I don't understand is how they go about that, to basically have a second trial for a trial that was lost, to say, not only did you lose that case, now it was so bad that we should retry you and have you dismissed or have you disbarred.
And especially not awaiting the judgment of those courts. So it's a problem of saying, well, he did something in some other court, and so we're going to punish him in this court without due process of law. And I think it's, and they're calling it due process. What the Delaware court did is not constitutional due process, in my view. And what they're asking the New York federal court to do wouldn't be constitutional due process. Once the pro hoc vice has been granted, due process applies before it can be taken away. But a lot of judges aren't aware of that. And I think that the complaint by the Georgia State Bar sort of jumped the gun. If they had a complaint from a court or a complaint from a client, that's where I think their jurisdiction is limited. Otherwise, it's a very precarious precedent to start politicizing these and weaponizing these ethical bodies to target political opponents. But it's clear it's what the left is going to do. Now, there's a history of it. If you were on the sort of independent left, independent right over the past 100 years, the state bar has often come after you. They went after, different, it wasn't state bars always, it was often courts, but those others too went after Clarence Darrow repeatedly. I think they tried to criminally prosecute him 3 different times. They went after Jim Garrison repeatedly. So there's just been an ugly history of how these, how easy it is to politicize these branches. But at the same time, Wood has made it easy for them to come after him and keeps making mistakes in his defense. So it will be something to watch because of the dangerous precedent it might set.
Well, I mean, the problem is, I think, a lot of it is throwing the spaghetti at the wall. You throw more than you need and hope something sticks. But I think they have a couple of good things which on their own might be sufficient for an ethical complaint in general. But the other question is, even if some tweets were over the top, even if, this plaintiff who never signed off on a suit has a complaint, where does it stop? What's the extent of the punishment? Is it absolute destruction? Is it a sanction? Is it disbarment from every state and no pro hoc vice? I mean, how far do you go with the punishment? Whereas if it were any other non-politicized individual, it might be a fine and it might be a 1-month suspension or whatever. Whereas with it looks like they're going to go everything in the kitchen sink after Lin for what might be legitimate sanctionable violations, but we'll see.
Well, the confessed felon Kevin Kleinsmith, to my knowledge, hasn't had any adverse action taken against him.
Well, politics ruined it. Where's my shirt? I had it. I took it off to put this one on. Politics ruins everything, and when it ruins the judicial and prosecutorial system, that is when people start losing faith. Robert, we just crossed 10,000 people watching live, and it is the good time to remind everybody we're at 2.2 thousand thumbs up. So hit the thumbs up. It's that little thing. Oh, look at that. I got an ad for this. Hit the thumbs up. The chat is always lively, so don't worry, leave a comment, but go hit the thumbs up and get it to 5,000 or 6,000, and that helps something in the YouTube system. Now, I wanted to get back to there is no more on Lin Wood. We'll see what's the time frame for what we should expect for a decision.
The Georgia State Bar I think will be a little while, but the New York Pro Hoc Vice decision probably will come down pretty soon. They're also using his statements. He really should have representation in these proceedings rather than trying to represent himself. The old statement that a lawyer who has himself for a client has a fool for a client.
No, so someone who has himself. Yeah, I don't know if it's a lawyer, but whoever.
Yeah, I always add the lawyer version because I think a lot of people can represent themselves pro se effectively sometimes when they can't afford a lawyer. So I'm not as dismissive of pro se people as the court system is. But definitely when a lawyer has himself as a client, because a lawyer of all people should know that's not likely going to work out well. They're also using statements that he made to claim that he made false statements to the court. He's giving the court an easy hook to deny him pro hoc vice appearance based on representations he made about what he did and didn't say on January 6th, because he said some very problematic things on January 6th as the events were unfolding.
No, so we don't need to repeat them. We want to not push any envelope, but everyone can know what they were. And Nick Rekieta does a good job actually referencing and showing images. Okay, before we get to the next subject, I want to read one chat which I brought up, but I didn't read it out loud. Matthew Zollinger says, "Hey, my wife needs some support this week. She graduated from law school and helped me beat cancer and needs some Barnes and Viva love." Matthew, double congratulations. And now I want to get to the next one, which is a segue into our next discussion. It was the first super chat. Beavis Wallace says, "From McAllen, Texas, life is mostly normal here. Ask Robert, when do government emergency powers expire in America? Is that a dumb question?" Well, it's a good segue. We'll cover the Dutch decision coming out of The Hague because it's a perfect segue into that. And then, Robert, you can answer the question from the U.S. side, and I can probably answer it from the Canadian side because we have a decision that's giving an indication. Dutch court, for all of you guys who don't know, declared the curfew in the Netherlands to be illegal, the lower court. They declared it to be illegal but not unconstitutional, a minor distinction. They declared it to be illegal or unlawful because it was enacted without using the proper legislative remedy. They said, this is not what the Emergency Powers Act, or whatever the equivalent is in the Netherlands. This is not what the Emergency Measure Act is for. It's for the example they used was the breaching of a dike, which is a bizarre example. I don't know if they use that in the judgment. In the article I read, they used it. They said it's for immediate emergencies. And a curfew, by definition, if it lasts a month, they didn't really say it like this, but they said it's not an emergency, so it has to go get voted by the House. It has to pass through the normal legislative process to get approved. The same day the lower court declared it illegal, the government filed an emergency appeal. Appeals suspended or stayed execution of the lower court order pending a hearing before the Court of Appeal. It was heard last Friday. From what I've heard from some people in the Netherlands who are emailing me and messaging me, the Court of Appeal is going to render its decision next Friday. So they're going to take a week to draft. So, I mean, that's the interesting thing coming out of the Netherlands, coming out of The Hague, no less. So it has a big name to it. Coming out of Canada, somebody, a lawyer in the Gatineau filed a lawsuit to declare our curfew unlawful in part. The judge said, no, on an emergency safeguard order like this, the law is presumed valid and you didn't allege enough to have it overturned on a safeguard basis. Robert, in the U.S., it's the question everyone's asking. When does an emergency cease being an emergency? I think we saw it in Michigan. I think we saw it in Pennsylvania. But what's the consensus under American law?
Historically, and because there was a great fear after what happened in Germany and the rise of the Nazis, they used the emergency exception that was written into the Weimar Constitution as their means of seizing and continuing to aggregate power and consolidate power. And so it was long recognized that one of the great attributes of the U.S. Constitution is that there was no emergency exception written in. Our courts, in deference to the executive branch, has simply allowed it to occur in some cases. In other instances, it's pursuant to legislative statutes that have been passed previously that often were meant for other things like floods, etc., riots in some cases. Theoretically, an emergency is something that the very nature of the problem cannot be addressed in enough time to allow the legislature to take action. That's what it should mean. That's the common sense constitutional definition of an emergency. It's, well, we would love to have it be passed by the House and the Senate, or however the legislative system is set up in a particular state, but we don't have enough time because the floods here, the hurricanes here, the tornadoes here, the riots are happening. By definition, that's really something that should be 72 hours or less, because the legislature can get together and pass a law in pretty quick time frame. And to give an example of this, the U.S. Supreme Court in 1866 said that Abraham Lincoln suspending the writ of habeas corpus in the northern states during the Civil War was unconstitutional, that he had no authority to do it. And that's a version of the emergency exception. They said, no, as long as the courts could meet, there was no grounds to suspend the writ of habeas corpus. So as long as the legislature can meet and pass a law, an emergency doesn't exist for emergency legislation. But what's happened is the judiciary has unduly deferred. And so we see these back and forths. We'll see a court like the lower court, The Hague, a state court in California, a state court in Michigan, a federal district court in Pennsylvania, step up to the plate and recognize the obvious. And then we'll see some other appellate court, more politically oriented court, step in and say, no, we don't want to go that far in deference. And that's why almost every major civil rights hot dispute is one the courts have often failed to take meaningful remedy, and often were the offenders at key junctures, like in the Korematsu case and the Buck case and the Connie Buck case, cases that I call the trilogy of infamy of our U.S. Supreme Court. So that's what an emergency should be. So we saw some hope from the Dutch lower court decision. Then at least the legislature stepped in and did actually take action. So at least that part of their own constitutional process was upheld. But there are aspects of that decision that could have gone further. The European human rights is very broad. Again, it's an old story. Constitution made of paper, blade made of steel. But we're seeing signs that at least more and more courts are starting to push back. Now, the higher courts are limiting their ability to be effective. But the fact that any courts are willing to point out the obvious is a sign that this cannot continue. And the courts are starting to increasingly indicate this cannot continue. And the fact that two biggest governors behind this, and this might be a good transition into Cuomo, one of them, Newsom, is facing a major recall, likely is going to be facing a recall ballot, despite their newfound interest in signature match checks in California.
I got to stop you there, because we mentioned this last week. Someone put in the chat, Newsom now wants to verify signatures on the recall. I thought it was a joke. I swear to you, it's Poe's law. In the absence of a clear indication, you can't tell what's parody on the internet. I thought it was a joke. It's not a joke. For what all that happened in the election, now Newsom wants to verify the signatures on the recall petition that has crossed the threshold of what was required.
And they're rejecting signatures at a 100 times higher rate than the election. It's amazing. I mean, now I think there may be litigation on this if it becomes consequential. If they try to strike so many signatures, they say the recall petition didn't pass, there will be litigation. I'm licensed in California. So that because and my argument would be real simple. The due process principles that they use to lower signature match requirements means we have to have one set of standards for signature match requirements. We can't say you can actually vote and put someone in office on a much lower signature match standard than simply to get something onto the ballot in the first place. And we'll see they're clearly applying completely different standards in California. And this goes to what we talked about with the elections in general.
Which we can no longer talk about now. And now the only thing you can talk about is Newsom he's justified in asking to verify signatures. I mean, it's a very serious thing to be recalled from office for your blatant hypocrisy and failed leadership.
Or you could be a Democratic congresswoman, have lost your election to Congress in Iowa, and you're asking Congress to set aside state certified election results. I thought that was really bad.
I cannot wait to see what happens. While we're on it, what happens? What's the process for the recall in California? Time frame, next steps, likelihood of success?
It will be within the next couple of weeks, because the deadline, they set a time period where you can gather all the signatures. That's coming up in March. Then they go through and check the signatures. And once they determine whether there's enough signatures or not, will give the right to bring a court action. If they say there's not enough signatures, it's going to court. If they say there are enough signatures, then no need to go to court, because then it's going to be one crazy recall petition in recall election in California, and I'll talk about that some tomorrow with Richard Barris on what are the odds.
Okay, awesome. What time do you go on with Barris?
At 2 p.m. Eastern Standard Time.
People's Pundit, Richard Barris, what are the odds? 2 o'clock Eastern Standard, which is 11 o'clock Pacific, noon Mountain.
Exactly. And then we got a good transition into Killer Cuomo. So while Cuomo was out there yipping away about Amy Cooper, just like Mayor DeStasio was, drawing false conclusions about this ordinary, everyday human being from the fine country of Canada, being wrongfully judged. And by the way, people should think about that, by the way. That means there might be multiple jurisdictions people could sue it. Just an idea. Maybe a great Canadian lawyer will step up to the plate and be co-counsel. So Killer Cuomo or COVID Cuomo or whatever a nickname. Maybe we'll crowdsource on locals the best nickname for Cuomo.
I'm reading through the chat. I mean, just wait. If only Trump were on Twitter, I'm sure he would have come up with a nickname for Cuomo. But Cuomo's name in and of itself is going to live in infamy. I mean, it is over the top. What's so offensive and over the top, it is what he's done. It is also in conjunction with the audacity that he had to try to blame it knowingly on other people. And to knowingly blame it on other people, I think I put this on Twitter in an undumb tweet. He tried to effectively blame his own failings on his political foe so that he could profit politically from his own negligence is too light of a word at this point because they knew what was going on when they were doing it. But he's trying to profit off the people that he is responsible for having ended their lives. And he's trying to profit off it politically by putting the blame on Trump. It's beyond the pale. But okay, sorry, the legal issues. What is he facing? Like, what can he face as a politician? Is he not going to have some form of immunity? I know sovereign immunity does not apply to criminal complaints. So what could he be facing for this?
So the big one, the easy one, probably the one they'll target him on, is obstruction of justice, because it appears he instructed staff members to lie to the Department of Justice during Trump's administration so they wouldn't know how many people his policies had killed, how many grandmas and grandpas he'd whacked. So that's the big one. That's obstruction of justice. That's a federal criminal investigation. So he can't hide behind his allies in the state criminal process. That's going to be a federal criminal prosecution. Now, it's the Southern District of New York or the Eastern District of New York. So we'll see how that goes.
He won't be able to hide behind his allies in New York, but is he not going to be able to hide behind his allies in the federal government and the new administration and Psaki, who seems to be giving him a pass on any form of public admonishment for the time being?
Well, there might be a vice president that would like to see Cuomo taken out of future competition. So the people might want to study Kamala Harris's political history. She learned her politics figuratively and maybe literally at the knees of Willie Brown. So Willie knew how to handle things. And so I think that's a substantial part of what's happening politically. That's why I don't think he'll get the political protection. I think that's why it's all developing. And all of a sudden the press is starting to cover this in ways that, they wanted to cover Ted Cruz going to Cancun when he's a senator. He's not a governor. He can't have any influence over what's happening in Texas, frankly. Probably not the most politically smart thing to do, but by no means that consequential. It's not like Newsom partying at the French Laundry while he won't let anyone else go out to eat in the whole state, and he's killing jobs and businesses in the process. But I don't think it's a coincidence that Newsom's facing a recall threat or that Cuomo's facing major public scrutiny. These are the two major potential contenders for 2024, using their COVID platform as the basis to do so. And one, that their policies have just failed in general. So that's problem one. But problem two is there's a vice president who has no interest in competitors like that being around. Kamala Harris makes Hillary Clinton look like a Girl Scout when it comes to politics.
Well, no, but that may be a legitimate point, but I think at this point, Cuomo's too damaged, indictment or criminal prosecution or not, he's too damaged for any future political use. But truth is, memory is sometimes short in politics. So I think the biggest problem, once his staff member came out and said, oh yeah, I was basically instructed to lie by Cuomo so that they didn't know, to the Trump administration wouldn't investigate us about what we were doing, that he was sunk. And now all of his political adversaries are coming out talking about how they were threatened this time, intimidated that time. So Cuomo's in serious trouble. He will, my guess, within a year, he'll either resign or face criminal prosecution. And I'm not, I swear to you, I'm not even asking this as a joke. It's going to sound that way because of the world we live in. What does he lose that Emmy award that he was given for his leadership? Like, do they revoke that? And I'm serious.
Yeah. I mean, it's Hollywood. So, but yes, it makes such a crock. They gave him an Emmy for killing grandma. I mean, so that doesn't make the Emmys look good. Maybe they give him the opposite of an Emmy. I don't know. I forget what they call those joke awards for like terrible films and the rest. But someone in the chat will probably remember the name of the satire awards for like worst film, basically. But he and Newsom are definitely up there for worst governors, maybe ever in their respective states.
What I do love, I just brought this one up. It says Cruz needs to stay out of it. What I love is the respective emphasis that the Cuomo awfulness is getting compared to Cruz is going to. Where did he go?
Cancun.
Cancun. Going to Cancun for vacation.
Which that probably was the crime.
No, it is. Wait, why?
It's Cancun.
Okay. Okay. I think first of all, so I'm not. Just so we're clear, I'm not judging Cruz. I think the optics are bad. The optics are bad, and you know the way it's going to be weaponized. People don't seem to appreciate that Newsom's hypocrisy is different. It's not when someone is sort of critical of certain government measures, they're not hypocrites for traveling. It's the ones who are telling you not to travel while they travel. It's the ones who are telling you to stay home in a tweet that they pre-shot and published while they're in St. Bart's, true story of Toronto. So Cruz taking the trip, bad optics. I wouldn't have done it. And you know the way it's going to be used. But to turn that into the scandal at the same time that the truth of what Cuomo did in New York is coming out, the media is not the friend of the people. I mean, it's quite clear that they are willing to. They're paying some attention to it, but they're willing to gloss over thousands of deaths resulting from negligent, if not outright criminal misconduct. To go after Cruz for a vacation that he probably pre-planned. It was probably pre-planned. If he booked it during the crisis, the optics will be even worse. But to even equate those things on the level of media attention that they've been getting is itself should be discrediting of any media organization, but it won't be. But whatever, people still like reading about it, and they like getting offended about it because it's Parkinson's law of politics. It's easier to get mad at Ted Cruz for his trip than it is to get mad at Cuomo for what he did, because one is a lot schemier than the other. Okay, rant over. What do we move? Do we nothing more on Cuomo?
Nope, I think that covers Cuomo. Well, I mean, it will be a test of the system, because while they're drumming up excuses to go after Trump, if here you have a policy, and like here one place they set a precedent, they required the governor of Michigan to plead effectively to what happened in Flint, and that's small change compared to what Cuomo did. So if Trump faces various prosecutorial actions, if the governor of Michigan, who is Republican, had to face it for what happened in Flint, then by golly, Cuomo's got to face it in New York. And if not, it's going to be an indictment of the criminal justice system again. And we're witnessing that in live time to a brief topic. But what Cernovich laid out was clearly correct, that there's a double set of standards being applied in the Capitol Hill cases. People that were arrested, people that are being charged now solely for wandering into the Capitol without there even being evidence that they knew they were trespassing at all, who committed no act of violence whatsoever, who didn't appear to even be aware of what was taking place. Jack Posobiec noted the phones were not working that day because they'd shut them down around the Capitol, so that you couldn't even know what was happening. And to now be not only charging those people, but imprisoning them without bail. They're charged with misdemeanors. The Eighth Amendment to the United States Constitution requires that bail be granted. The only limitations on that are clear and convincing evidence that there's no set of restrictions whatsoever on that person that can preclude their appearance at trial, that can assure their appearance at trial. And so instead, these D.C. judges, clearly the D.C. Circuit, D.C. District Court, is looking like it's so political and so partisan that it simply cannot constitutionally apply the same set of constitutional standards to people. This is the same D.C. court system, by the way, that allowed almost everyone who committed actual violence during Trump's inauguration to walk with no consequences. And now they're jailing grandmas. They're jailing people that just wandered in, that there isn't even good basis to believe they're guilty of any crime in the first place. And they're only charged with misdemeanors, and they're being locked up and held without bail for who knows when they're going to do a trial. So it's a repeated constitutional violation of what's taking place there. And it is a morally offensive behavior. And it's our DC court system failing us. And it's because the media and the Department of Justice has no interest or incentive to be constitutionally fair. And they're educating the world, right? That they can they can find every single person who wandered into the Capitol within days and bring the whole force of the government down against them within weeks. But they could never seem to find their way to figuring out how to prosecute or punish anybody seriously connected to Spygate.
Well, Spygate is one thing, but also just talk about the riots that happened throughout last year. I mean, they were literally raising funds to bail out the rioters who were arrested, which actually brings me into a question which we've discussed privately, but it's good for everyone to know. People are discussing whether or not Kamala Harris could, in theory, be impeached for things she said about, I think it was about bailing out rioters who were arrested and gathering bail to get them out. Could she now be impeached for those comments made before she was in office?
By the Democrat standard, yes. By my belief of what the Constitution standards are, no. Because in my view, it's got to be illicit, imminent incitement speech, and it should be while you are holding office. I don't think impeachment is an appropriate remedy for conduct that occurs when you're not holding office, number one. And number two, I don't think impeachment can be used for constitutionally protected activity, number two. So I think it needs to be a crime. I think it needs to be a serious crime. And I think it needs to be a serious crime that has a nexus to the office. And I apply that standard, whether it's Kamala Harris or Donald Trump, it's being applied to.
Yeah, that's it. I mean, it's a good point, and it's an interesting question, and it'll be interesting to see if Republicans want to fight as dirty as Democrats, and if if the standard that the Democrats have set for impeachment are going to be good for the gander, if they were good for the goose. Leverett says, for googly-eyed glasses for when Winston is confirmed he can no longer see. Yeah, I'm not going to play games with the dog because I don't want to be accused of objectifying the dog, but we'll see. If his eyes have to be zipped shut, maybe we're not going to put in what are they called? Prosthetics. Oh, and sorry, here. Isn't our international reputation taking a hit with this unequal justice system? We can't preach democracy to the world. I can tell you from my perspective and reading a lot of chat of international comments, I see a lot of people in foreign countries who are not too impressed, to put it politely, seeing what's going on in the United States, judicially, politically, election-wise. In Australia, it's photo ID, and sure, you get a fine if you don't vote, or you're legally required to vote. It's photo ID everywhere in the world. For people to now look in the United States and see that they're doing mail-in with no signature verification because everyone's deemed indefinitely confined, yeah, it takes a bit of a hit because people cannot fully understand the arguments that are being raised in the U.S. to allow this type of voting. But
and the International Court of Public Opinion is increasingly judging harshly the overreaction to the Capitol Hill cases. When they're starting to lock up grandmas that wandered in that had no knowledge or notice of what was taking place and then denying them bail, while the same Biden State Department is lecturing Russia about locking up a guy rightfully convicted of fraud in Navalny, Russia's like, hold on a second. We locked up a guy who was convicted of a fraud crime years ago and violated his probation. You're locking up every grandma protester you don't like. You want to say you shouldn't lock up your political opponents? Sure looks like that's what the United States is doing en masse. So the degree of lack of self-awareness is striking, but it is reflective. Now, I think for some of those who want to transition briefly into the SCOTUS context, there's some misinformation out there. The Supreme Court on Friday had a conference on whether or not to take a bunch of election cases. They've already voted. We just don't know what the vote is until Monday morning. Usually 10 a.m. Eastern time, they announce whether they decide to take the case or not. For some reason, Sidney Powell is saying there might be an opinion by Thursday. I don't know what she's still on, but it's not. That's not it. So on Monday, most likely they're going to turn. I think they'll turn all, but they're going to reject all the Lin Wood cases and reject all the Sidney Powell cases. They've made those cases radioactive by their own course of conduct and all of this. So the question is whether one or two of the Trump cases that are there, because Trump dismissed almost all of his cases, but there are a few that were all the way already at the Supreme Court. Those he didn't dismiss. So particularly concerning Pennsylvania. And so they may take one. I believe they should take one. Take the Trump Pennsylvania one that gets into the issue about whether the whole way they did their whole, and use that as the example to say, for future reference, here are the rules. The court may be scared to take one because they'll be, validating and vindicating, quote unquote, any theory that Trump had about the election, despite Time Magazine kind of doing that for everybody.
That was actually
but I hope they take one. Chances are they don't take any. And we'll know Monday.
And if they take one, it could potentially have an impact on the proposal HR1 in terms of
it could. It's somewhat. But what it could definitely do, at least as the presidential elections, because my interpretation of HR1 is that they can do that for congressional elections. I don't think they have that authority for presidential elections constitutionally. That could be reaffirmed, but just as important, they could set the parameters for future elections. Say, here's who can do elections, here's who can't, here's who can set the rules, here's who can't, here's how these rules either conformed or didn't conform to the constitutional requirements. And I think that would be very beneficial for future guidance. And I think they were at least inclined to do that before the election. They were just going to wait until after the election. But the question is whether everything that happened on January 6th and how that's been interpreted in the public narrative, all of Wood and Powell's conduct, whether it has so undermined the impression of those cases that they just stay away from it altogether.
Okay, interesting. And I'll bring this one up. Tom Viller says, with the DC jury pool and judges 90+% Democrats, any hope of using one of the 1/6 cases to find out what Pelosi and other high-ranking officials knew before trespassing took place?
Well, Tom provides a perfect transition to the case that offers that opportunity. The criminal cases could get into QAnon and the rest, but the case that provides that perfect opportunity, if he chooses to go this route, is the Democratic congressman that is now suing Trump, along with Giuliani, Oath Keepers, and Proud Boys, and all the rest, on the grounds that Trump violated the Ku Klux Klan Act of 1871. And those have different sections. And so there's Section 1, Section 2, Section 3. It's very rare to see Section 1 lawsuits. So what was happening was the Klan was terrorizing black citizens and anyone else, including white Southerners, who supported civil rights in the South after the Civil War. And so they were intimidating them in three ways. They were intimidating federal officials from doing their job. Second, they were intimidating courts and intimidating people from being witnesses or jurors. And third, they were intimidating people in the exercise of their civil rights. Category 3 is the most common kind of claim brought, and that requires race-based animus or other forms of class-based animus. Category 2 involves witnesses or jurors. That doesn't apply here. They sued under Category 1, where there's very few lawsuits historically. Because effectively the 1877 compromise with the 1876 election basically negated enforcement of that statute for a long time. But so the allegation of the congressman is that Trump conspired with Rudy, conspired with the Oath Keepers, conspired with the Proud Boys to cause the raid on the Capitol, and it was all about preventing the poor congressman from being able to vote on the election contest issues.
And now my understanding of the lawsuit is that the evidence on this collusion is thin, to say the least, non-existent, to put it more accurately, and relies, from what I understand, pretty much exclusively on the comment that Trump made in response to the question he was asked during one of the presidential debates, stand down and stand by, which is basically the evidence, according to the plaintiff, that Trump was conspiring with all of these people to prevent Congress from doing what it was, supposed to do.
Correct. It's legally insufficient in my view, right on the pleadings. I agree with Nick Rekieta on this. Because in order to allege, you have to allege after the Iqbal decision, there were some, and Twombly decisions, there were cases that were basically trying to hold Ashcroft responsible for a lot of bad things that happened after 9/11. U.S. Supreme Court stepped in and created, I have problems with how they decided to do it, but that ship has sailed, a higher pleading standard. So they're like, you can't just allege conspiracy. You can't just allege fraud. You have to allege the facts that legally constitute conspiracy. And here, what they needed to allege was that Trump communicated with the Oath Keepers and communicated with Proud Boys and directed them to at a specific time or date to go into the Capitol for the purpose of preventing the congressman from taking action. They don't have any of those allegations. They don't even have Trump talking to Oath Keepers, talking to Proud Boys. They don't have Rudy Giuliani talking to anyone, nor do they have Trump ever saying he wanted anything, any invasion of the Capitol, nor do they have Trump saying he wanted any congressman not to act. So they don't even have the basic factual allegations. But what they're banking on is that it's the D.C. court that they brought it in, and because that court is so overtly political, it makes the Southern courts of the 1950s look like beacons of due process and political impartiality in civil rights cases by comparison, and is their only hope that it survives a motion to dismiss. There's also sovereign immunity problems. They're pretending Trump didn't do this in his presidential capacity, which is ridiculous. So Trump could probably get the case dismissed on the pleadings. I'm sure he'll probably take that route. But somebody along the way could use that. One of the other defendants or Trump could use it as an opportunity to inquire into what Nancy Pelosi knew, what Mitch McConnell knew, what the Capitol Police was told, what the seventh floor of the FBI did, whether QAnon was a deliberate government misinformation campaign, etc. We already know by inference of the impeachment proceedings that they have no evidence that Trump wanted, desired, directed anything that happened at Capitol Hill riots. The evidence was to the contrary. So all they had was just basic, what everybody already knew, speeches where he's talked about peaceful, patriotic protest, etc. And so given that, he should definitely win on the facts. He should really win at the pleading stage, but he could use it as a discovery tool, or one of the others could use it as a discovery tool to get into what Pelosi really knew, to get into what McConnell really knew, to get into what the seventh floor of the FBI, did they lie to the Capitol Police to instigate those events? How many informants were part of that? And for people who want sort of my own deeper inside take on it, they can watch the Hush Hush episodes at vivabarneslaw.locals.com.
It's amazing. I mean, the production value is amazing because it's scripted like a novel. I say this every time. And Robert has a very interesting take on what something would look. I think we talked about it last week. Interesting take on what something would look like if it were a false flag setup type thing. What was I just about to ask about this lawsuit? Sovereign immunity, cross claim. Darn it! I lost my thought. Doesn't matter. Tabarouette. I totally forgot what I was about to say. Okay, so they've sued. It's presumably going to go nowhere.
It shouldn't go anywhere. It's just because the court is located in that raises questions.
But there would be no countersuit for. I mean, what could they countersuit for, and who could countersue?
I don't think he would want to countersue in the D.C. court. So if he wants to countersue or bring a suit himself, he'll bring it out to her. He's not inclined right now to go that route, given his experience in the court system. He will be speaking at CPAC. He is getting back politically engaged and involved. But I think mostly it's a case that's not going to go anywhere, shouldn't go anywhere. But there's a risk that it does go somewhere simply because of the political court in which it's being held.
All right, excellent. I guess that might be the good segue into talking about corruption, collusion, big tech, working with government. Do we talk about the Biden social media discussion as to the suppression of not suppression, fortification, as I'm jokingly calling it now, of information in terms of government actually now asking for assistance from big tech to suppress misinformation online? Are we now, we've seen the progression of lawsuits against YouTube, Twitter, Facebook, going after, the First Amendment arguments, the municipal city type arguments. Are we now not getting a little bit closer if we see overt collaboration between government and big tech?
Well, it was fascinating timing because we had 3 articles come out this week about this. And it's while a suit is currently pending by Robert Kennedy Jr.'s Children Health Defense against Facebook that was alleging this had already been taking place, that the CDC and other government agencies were conspiring with Facebook to censor and suppress independent information that raised questions about the CDC's interpretation of its own data concerning the safety and efficacy of various vaccines and other medications and therapeutics and other forms of treatment. And they basically removed some of their ads, did some other discriminatory actions, and they have a motion to dismiss pending against them. They fought back. Their allegation is that the First Amendment applies because Facebook was acting as an agent of the government in doing what they were doing, and they already had reason to believe that was occurring. Well, while that motion is pending, 3 stories come out, one from the New York Post, one from The Hill, one from Glenn Greenwald, confirming that, in fact, there is since Biden has been in, they've intensified that. The Biden administration is colluding with big tech to suppress and censor any information that raises any doubts about the COVID vaccine in particular, but also other governmental actions in the public health space. And they're demanding that Facebook censor, suppress, manipulate information and data to prevent that information from being received and heard and distributed to the public. And one of the, the guy that's on the front of this to many degrees is Robert Kennedy, who's, contrary to what people said, he's not an anti-vax or anything about it. He just believes you need to always have a public debate about public health issues that impact people's privacy and have informed consent consistent to the Nuremberg Agreement, Nuremberg Code after the Nuremberg trial, which said we were never going to do that Nazi experimentation again or allow any form of civilization or society to do so, despite our own horrendous Buck decision by the Supreme Court decades before that the Nazis actually relied upon and utilized for their own authority. And as Dershowitz noted, it was one of the most horrendous decisions ever issued in the history of the Supreme Court. Might have helped persuade him on some of the aspects of the logic as well. There's some emotional strings you can play there, but it's a horrendous case for good reason, good cause. Because of it, I think it does. I think for people who don't know, if a private actor is actually acting in collusion, in conspiracy, in cohorts, in coordination with the government to do something, then there is evidence that they can now be held liable under First Amendment standards because they're acting as an agent of the government. And this goes all the way back to the old civil rights laws, part of the Ku Klux Klan Act and the like, passed in the same time frame. The concern was what happened when you have someone like the Klan, private organization, acting at the behest and behalf of government authorities to suppress civil rights and civil liberties. They created laws that said no, private actors can also be responsible when they're in collusion with government authorities. And now we see 3 stories: the New York Post, The Hill, including left-wing Professor Cherminsky from USC, saying this is a problem, and also the article by Glenn Greenwald. So you have Dershowitz come out against this, Turley come out against this, Cherminsky come out against this. Now Glenn Greenwald come out against this. Now other people coming out again. He's also a lawyer. So you're seeing a lot of lawyers on the left condemn what's taking place because they recognize the value of a robust debate. And the main plaintiff in all of these is a famous left member himself, Bobby Kennedy Jr.
And it's an amazing thing. First of all, I know it's only a matter of time before I get accused of being an anti-vaxxer because, the idea that you should support freedom of speech is somehow makes you guilty through demonization and guilty by association. I didn't even realize how heated the debate was when I made a video a while back about having cut my finger metal detecting, and I went and got a tetanus shot. And then everyone's like, oh, you got a vaccine. And like people, I didn't even think of it at the time. So I am by no means an anti-vaxxer. And with that said, I don't think you convert people from being anti-vaxxers by suppressing their ability to have discussions and shutting down YouTube pages. And it's gotten so bad. My wife, everyone knows, she's a neuroscientist. She is in a neuroscientist community. They're now being censored from putting posts on Instagram, and I think Facebook as well, that reference vitamin D, taking vitamin D because it's related to the Rona.
It's proven to be very good. People that have high vitamin D levels in populations in countries that have high vitamin D levels are seeing far less negative adverse impact from COVID. So it's like, why are we discouraging people? You can take vitamin D and get the vaccine. My view of the vaccine is let's have a public health. I'm not an anti-vaxxer. Bobby Kennedy's not an anti-vaxxer. His kids have got almost all the vaccines. He himself has got almost all the vaccines. It's simply making sure there's public choice and informed consent. And we can't have informed consent if we removed informed from the process. And that's the problem. And we can't allow the Buck line of logic to ever become public health policy anywhere in the world, or we will get Nazi experimentation again. So that's why I find it morally horrendous. All the white lab coat crowd said eugenics and sterilization was a great idea in the 1920s. And you combine that with the power of the folks in the black robes, and we got one of the most morally horrendous decisions in the history of American jurisprudence. And it was the main citation used for the Korematsu case, the second worst decision ever issued by the United States Supreme Court. Third would be Dred Scott. Fourth would be Jacobson. But we cannot go back down that path. And Bobby Kennedy Jr., I mean, he's like his father. Yeah, he's someone with a deep conscience who just asks questions. And I think, and that's it. And the attacks on him are insane. But I think people who are conscientious on the left, our lawyers, are starting to wake up. I mean, Dershowitz disagrees about some aspects of what's required for the vaccine, but he agrees that Bobby Kennedy should absolutely have free speech to raise questions and about its efficacy and safeness so that we have the informed word in informed consent.
And for anybody who wants to have their minds absolutely blown, just Google RFK Jr. and just read the articles that come up. If they refer, you'll be flabbergasted. It's like the media is working in cahoots with big tech, who's working at the behest of the big government now. You will see it's crafted. They kick him off social media platforms so they can besmirch his name in article after article that, by all accounts, somewhat misrepresents his position.
Oh, completely. I mean, frequently they said he lied when he didn't lie. He shared information. And to go back to a commenter from last week, no doubt CDC does not agree with Bobby Kennedy's questions, or mostly he asks questions rather than makes statements. But to the degree they don't agree that their own data means what he claims it could mean. No doubt about that.
Now I'm going to stop you. I'm going to stop you there, Robert, and we're going to address a comment that someone emailed me from last week, that the CDC, and you posted a response to the question. I posted an update in one of my videos, but we'll do it now as well. The CDC stats on their webpage confirm, they call them vaccine adverse effect report something. So VA.
I think it's VAERS or VAERS. Yeah, and this is where the data comes from, where there's a dispute is about the interpretation of that data.
Right. So the data says there have been 1,170 at the time deaths reported through VAERS, which is the Vaccination Adverse Effect Reporting System. That's what it was. Now, so the argument is that anybody can file a report through VAERS, and there's no, there's no immediate causation correlation. Anybody can file a report. Then the CDC apparently is supposed to go investigate. Their conclusion is, yes, we've received various reports to the effect that 1,170 people have died in proximity with the vaccine, but their investigation reveals no causal effect between any of them. So that is to correct the number that, what you said last week was that the CDC confirmed that there have been X amount of deaths resulting from. That is the disputed element. There's numbers through the VAERS system. CDC says no correlation, and Robert F. Kennedy apparently was asking too many questions, and they booted him from social media. And that's what needs. And
that's where there was no misinformation. He was citing their data, and it says, the question is what the impact is. CDC has its interpretation. He has questions about the accuracy of their interpretation. And as I pointed out to that commenter, I was like, the CDC right now has contradictory standards. They're saying if you have the vaccine in you and you die, even in quick proximity to it, there's no causative relationship. You have to go further to prove that. But if you have COVID in you, maybe months before, and you die, we're going to call that a COVID death, even if there's proof there's no causation. So which is it? The COVID vaccine has one medical standard, and COVID has a completely different medical standard. It suggests political manipulation of the data.
Politics ruins everything, especially science. And, my wife has a colleague who was talking to her and saying, yeah, I can't post articles about vitamin D on Instagram and Facebook. And then apparently went on YouTube to Google censorship and came across the Dave Rubin episode with Dr. Pinsky, Dr. Drew Pinsky, and Dr. Z-Dog MD, Zubin Damanian. And some lawyer was talking with them, and she didn't know that.
Yeah, some Canadian lawyer, some controversial Canadian lawyer.
No idea that lawyer was her colleague's husband. But it's like, the scientific community now is starting to feel the effects of this, where big tech is playing overlord in a world in which they have no expertise. And so it's a crazy thing. What's more dangerous? Free speech, where people might adhere or be subscribed to the wrong ideas because they don't have enough information, or shutting it down, thus, in fact, confirming to far more people that there must have been some truth to it, lest you don't, when you cut out a person's tongue, it's out of fear of what they're going to say. You don't win the debate. I've mangled that expression. But it's like you have big tech now playing the role of MD. You have big tech now playing the role of expert, as opposed to having an open debate about it. And, if some people get misinformed, some people get misinformed.
My view is if they're right, They shouldn't be scared of debate. Number one, I have that principle in general. Number two, I don't trust any system that says we can't allow juries to determine this. We can't allow the public to know the facts. That if there's any dispute about a vaccine, everybody's immune from liability. And if there's any degree of responsibility, it's going to be in a secret court in DC by some bureaucrat that's not public and without a jury. My view is and for folks that don't know, the reason why they created that whole system was because they got caught screwing up during the swine flu vaccine that was issued in 1976 that led to disastrous public health consequences that the media has tried to memory hole, because if people recognize that context, they might be like, hold on a second, let's make sure we have a full debate so that we can have informed consent. And if you want the vaccine, God bless, get it, get it. If you have problems, if you want more information, you're entitled to that under the informed consent principle, and they're trying to preclude that. And Bobby Kennedy may be the one to hold them responsible if his suit is able to go forward in federal court, helped by this critical information that this is a coordinated campaign by the government ordering big tech to take these steps.
Now, does it become a Marsh v. Alabama type argument, or does it just become another principle of law? And for those of you who don't know, we discussed it last week and many times. Marsh v. Alabama is the corporate city, which is technically not a government entity, an incorporated city. Sorry, it's an incorporated city, but basically acts as the government, therefore should respect the Constitution. Does the argument now become a Marsh v. Alabama, or is it another extension of another principle? That
it goes further, because whereas Marsh v. Alabama said that once you become a monopoly of the public square, you have First Amendment obligations, then the Supreme Court pulled back on its meaning on that, though the Supreme Court in California continued it, the Prunier Doctrine, applied it to a private mall. The U.S. Supreme Court did not. In this particular context, they get to go beyond that, because it's always been recognized that if a private actor is acting at the behest or in collusion or with conspiratorially with the state, so that they're effectively the state's agent, then the principle is this: the state can't get around the First Amendment by having a private actor enforce their will. So the only question then becomes, are they a state actor? And these stories sure show that they sure seems to be strong evidence enough to get to the discovery stage. And Bobby Kennedy's suit for the Children's Defense Fund is the named party, or Children's Health Defense, is the named party, could get into some very interesting discovery. And maybe Instagram and the rest will regret taking on Bobby Kennedy Jr. They may have they may have crossed the Rubicon when they did that.
Yeah, it's fascinating. I mean, it's to some extent confirms what we know. I'm surprised that the Biden administration would be so overt about it. Like, typically you'd keep it on the hush hush, in the worst sense of hush hush. It would be the wink of the eye. Big tech would do the bidding for the government, but you would never actually confirm it. But with the audacity of the Time article, and now fortifying elections, and now they've got to fortify information, it's almost like, I get the impression they've set the table, they've set the tone. This is how it works. It's not corruption when it happens. It's just for your own good, and there's nothing wrong about it. And that may or may not fly when it comes to this type of, effectively the government doing indirectly what it's not allowed doing directly, which is acting as a government entity, but also not respecting the principles of the Constitution. So it will be fascinating. Do you know anything that you're allowed to talk about of the Children's Defense lawsuit, strategy-wise, or upcoming strategy, change of strategy?
Not that I didn't authorize to discuss.
Okay.
So I'm just discussing at this point what's in the public record. It's publicly known that I support the cases and support the suits and will help in any way possible. But they can read the motions to dismiss are pending. The response to them are very well argued, very well drafted. Credit to Bobby Kennedy for recognizing this from the get-go. It's just someone that it's like the second half of his father's career. It's fascinating. I mean, there's a reason why I was a big fan of his father. The world might have taken a different path had he not been assassinated, his father. So just a deep strike. Whatever people think about the Kennedys, I know my friends on the right aren't necessarily fans, but there's a streak of Kennedys that even people on the right have usually acknowledged, that know about it, that's just very conscientious and that ask questions wherever those questions may go, regardless of where they may go. And so he's in the best of the Kennedy family tradition in bringing these issues to a head.
All right. And now I did remember when I went blank before, what I wanted to say was that, in fairness, Trump, after having said peacefully and patriotically, he did say 50 minutes later, fight like hell for your country or you won't have a country anymore. So I want to present both sides so that no one says, oh, you only picked on that.
And the beautiful thing there was he, in his Senate, the best part of his Senate proceedings was his media team put together that video that showed all the times every single Democratic senator, and especially Joe Biden and Kamala Harris, had used the exact same verbiage, sometimes in more problematic contexts.
Even Plaskett, when she came up to defend against it, thanked her fellow colleagues for fighting up with her. She actually said the word fighting up with her. It was politics. The other thing on the same subject, people had asked about double jeopardy. So Trump has now been acquitted on the impeachment. Even assuming there is the basis for probable cause on a criminal proceeding, assume that is there. Would he be protected by double jeopardy, or impeachment has nothing to do with the first part of double jeopardy?
It generally does not. That precise question in the presidential context has never been litigated, but it generally won't have any bearing in terms of evidentiary finding concerning any subsequent proceeding. I don't think in Georgia or in D.C. they have any basis to pursue criminal prosecution. Georgia was a civil settlement discussion negotiation. There's no basis for what that ambitious prosecutor is seeking there out of Fulton County. That doesn't mean they won't try, but there's no evidentiary basis, and they're going into constitutionally questionable territory by even trying to get there. And D.C., same deal. They know that doesn't meet imminent incitement. I mean, even the Congress members really didn't try that hard, the Democrats, to make that argument. They tried to say the Constitution didn't apply instead. So, and in New York, going after him on tax charges is nonsense. I mean, I've had more success than any lawyer in American history in criminal tax cases. So I, unlike legal, know what I'm speaking about. Trump faces no realistic risk of any conviction on tax issues because he has the reliance defense, the good faith defense, a bunch of other defenses. The tax may not even be due defense, no deficiency, all unique to the criminal tax context in New York because he had lawyers and accountants that did it. And it's very commonplace for a real estate guy to have those benefits. And New York would be taking a major gamble by trying to go after Trump on those grounds because they would be telling every real estate person in New York at the same time they're suffering a real estate collapse, don't get near New York because if they don't like your politics someday, they'll try to put you in prison for doing a real estate deal.
This is the angle that I love because most people would never even think that next step in terms of consequences, that, yeah, it would be a massive deterrent for the rebuilding of a city that is in massive need of rebuilding. Amazing point. Now, Roshan Kerdzaliev says, can you ask Barnes to clarify the case he referenced that was used as the basis for the Korematsu decision, the one with the white lab coat eugenics?
Two. One is Jacobson. The most horrendous is Buck, Connie Buck. And there's a documentary that's a tear-jerking documentary in the late 1970s about the small Virginia lawyer who went to bat for some of the victims of that. And you can just watch some of the stories of the women talking, and it's just amazing. So the Supreme Court should have apologized for that decision a long time ago. But they're instead borrowing the logic from it. Jacobson was the only case cited as the basis for Buck, and then Jacobson and Buck were cited as the basis for Korematsu. And they're the trilogy of infamy for good reason and good cause. And so that's what they're trying to reinstate, in my view, with the legal jurisdictions they're doing today. So hopefully, I mean, there'll be some cases going up to the Supreme Court. That might be a good transition to the takings cases that are pending in two different contexts. There's takings cases now pending related to the Texas energy disaster, and there's takings cases pending on the lockdown. So which will be going through it.
Explain. Well, let's start. We can start with Texas, but explain what a takings case is in the first place.
Sure. So there's both the United States constitutional provision, and then many state constitutions have their own analogous and sometimes more expansive protection. And what is the government cannot take your property without compensating for it, without just compensation is the phraseology under the U.S. Fifth Amendment. Similar language is used elsewhere. Sometimes the question becomes what constitute a taking. Obviously when they take your property, eminent domain, that's a taking. What happens when they just don't allow you to use your property profitably. What happens when there's something called regulatory takings, where they put such restrictions on your business that they do the same thing as taking your property. This particular U.S. Supreme Court has been inclined in favor of expanding Fifth Amendment protections in the takings context. And there's multiple suits, one recently filed in Michigan, one's currently pending in Pennsylvania, more that are coming, that say, look, these lockdowns were effectively takings. They took away my job. They took away my business. They made it impossible for me to conduct my business by rule. And that was a taking, and they didn't compensate me for it. What's relevant, pertinent here in part from a political perspective, is the lockdown has been used as the pretext for a massive redistribution of wealth and power from small business enterprises to the wealthiest oligarchs in the world. And the argument is a simple one. The argument is those people I shouldn't be the one to solely pay for this, even if it's to a public benefit that this take place. I shouldn't be the one to bear the entire burden of that. The state has to apportion that burden proportionately. And the one way they could do so is tax some of those big boys and give it back to me. But that's the theory behind it. Also, takings legislation, primarily its effect is it discourages and deters the government from doing these kind of things in the first place, because they often can't even afford to pay the amount of money that they are causing harm for. Sorry, go ahead.
No, I was going to say, did we see a takings argument made in the CHOP lawsuit, where they were basically saying that the government had deprived all of these people, by virtue of not supervising, of their ability to own and operate their businesses? Was that a takings argument?
Yes, in part. Yes, it was. And in Texas, it's the same argument against the various energy groups. It's that they basically took away my property, my home, for a week or however long, because it deprived it of its use, because it had no power necessary for its use. And that was a taking under the Texas Constitution without just compensation, to try to apportion accountability in that respect. And it's one of the main suits that is challenging. There's other suits challenging the Texas energy context and the lockdowns as well. But that's a basic overview. The other suits, there's a sovereign immunity issue with the main organization that's responsible for energy distribution in Texas.
Hold on. Before you get there. So for everybody who knows, I only read articles. I didn't read the actual lawsuit. The argument in Texas is that these energy companies, in order basically to deal with the crisis, started in enacting or imposing rolling blackouts, where they were taking energy away from some places in order to apportion to others, so as not to blow the grid up. And I don't know how that works. And then the argument now is that by virtue of them making a decision to take away energy provided to certain individuals, that it's a takings argument. The place where it becomes touchy in terms of sovereign immunity is whether or not these energy providers are government entities versus private entities.
And there's some that are private entities. The main group and organization that governs it has historically been interpreted as a government entity for sovereign immunity purposes. Indeed, right now, what's interesting is there's a case pending before the Texas Supreme Court on whether sovereign immunity applies to them. So bad luck for them that that decision is going to be made in this context, where there's going to be major political pressure for them to be held accountable, primarily because they had been previously warned in 2011 of exactly this problem and didn't take remedial action. Now, the other lawsuits you're going to see coming now, turns out like the Biden Department of Energy didn't come to their assistance and may have helped exacerbate the problem. There may be some consequences flowing from that. There may be some private companies that sold back their energy at it, like that had pre-bought energy and then sold it back at crazy prices. There may be some collusion. There may be some wash sales that took place. So there's a long history. If people go back, utilities have been sued around the world for a range of issues. California, they're sued all the time for fire problems, mudslide problems, blackout problems. Famously, Enron was involved in that back when Enron was a company, controversially, about how they handled certain things. And so there's allegations, cases around the world, and there's going to be more cases. There's a wrongful death suit that's been brought on the grounds that this was that a kid died because he didn't have access to basically, he was blacked out and frozen out. Literally, and that they're responsible because they could have taken very easy, basic actions that could have precluded that consequence from occurring. So there's going to be a lot of lawsuits coming in Texas.
Now, I'm bringing this chat up because I don't know if it's true or not. What about the poor people that got $16,000 power bills? Did that actually happen?
Yes. The crazy bills are being issued, and that's where if it's going to turn out that there was some collusion, some big companies maybe sold back their energy at a way inflated price because they could after they pre-bought it. There's a lot of people. The whole utility business has a lot of ugly underworld to it, and it'll occasionally pop up in the occasional public debacle where facts about them will get exposed. And so that's where people research it. There's all kinds of scandals involving utility companies going back decades. I mean, they're regulated because of their history of problems in part. So there's going to be a lot of suits and a lot of questions over what happened, because especially the basic problem was they were clearly on notice of the issue and didn't fix the issue. Whether you blame the windmills, whether you blame something else, they had notice of, here's your specific problem, here's how you can solve it, and chose not to take action to solve it. And when put under pressure, appeared to favor big boys at the expense of little folks. So downtown Austin is all lit up, while people out in the outskirts don't even have warmth.
Now, I want to bring up, it was a J Mill super chat, and I want to bring it up because I also love that avatar. That is a beautiful, that looks like a brown trout, if I'm not mistaken. And you changed your avatar, Jay. I'm in Texas. We're hearing think DOE's Department of Energy denied a request to temporarily lift regulations on output to avoid a problem because of green standards.
It appears the Biden administration did precisely that. What's interesting is the media is so badly in the bag. I never thought they could be more in the bag than they were for Obama, but they are. That if Trump had done this would be 24/7 scandal. That they would have been blaming everything that happened in Texas on Trump. They would be attributing it to his lack of support of climate change or whatever else, his lack of management style, his chaotic structure, all of those buzzwords would be used. And where here there appears to be actual culpability on the Biden administration's Department of Energy, and Biden didn't even grant the scope of the emergency request that was made. He only gave it to some counties, not all the counties. It would be massive scandal, but it's clear the media is so in the bag. They're just going to act as the press secretary for Biden. They're a joke now. I don't know how Jake Tapper can take himself seriously. I know he likes to take himself seriously.
No, I see.
I mean, this is a crock.
No, but between Tapper and who was the other one? Dan Rather, Harwood on Twitter. I mean, these guys, it's a joke that they are literally Biden trolls. That mean that all that they do right now is SH asterisk T post. Bless you. They just poo-poo post on Twitter for political purposes and give the Biden administration a total pass. There's no journalistic integrity left. I don't know if there ever was.
Well, go back and watch the MLK film I referenced earlier and see if you see a young Dan Rather asking J. Edgar Hoover spoon-fed questions to Martin Luther King. And that'll tell you something about old Danny boy.
Someone just brought up a question. So first of all, actually, before we get to that question, the chances of success, because I tend to think you get into these crises, which are environmental, I say unforeseeable, but everything's technically foreseeable, but they're natural disasters. We had one in Quebec in 96 when people were out of energy for months in some places. Generators, you couldn't buy one. I remember my father found a place, called up. There was one available on a Sunday, ran out and got it. We had been out of power of electricity for 5 days, and then we got a generator. But people were out for weeks. People died. It was 96. I was not conscious enough to know if anybody sued. But, I mean, what are the chances of a success on a lawsuit, even on the basis of takings, when they are responding to an emergency?
It's going to depend heavily on what the Texas Supreme Court does in that unrelated case about the scope of sovereign immunity. That's really going to dictate and shape their degree of remedy. Otherwise, it's going to take creative discovery in some of the other cases to get the private actors held responsible. Otherwise, it's a very tough thing. And here, it may be in part the Department of Energy facilitated it, which would take them off the hook potentially. So I think but Ken Paxton, the Attorney General, who's very aggressive and very politically savvy, has opened up a broad-scale criminal investigation. And Governor Abbott's not going to sit quietly on this either. So he's not going to take the heat for it. So I think there'll be major legislature will open up major hearings. So I think we'll get to more of the truth no matter what. The degree to which a jury holds them accountable is going to heavily depend on what the Texas Supreme Court says in that other case.
Okay, excellent. Now, let's see. We've got, let's say, 7 minutes left so we can keep it at 2 hours. What do we have on our list? We're both frantically going to make sure we covered all of our topics here. I think we did good, Robert. Oh, there was the Twitter loss.
The mask suit was asked a lot. I filed suit on behalf of a plaintiff bringing claims under the ADA, the discrimination laws related to disability, because a bunch of people, including a state hospital, it's a private hospital, but connected to the state, basically denied her access to medical facilities. Another place wouldn't, after she got in line to get her groceries, ran her out of the grocery store, even though she's at a stage 3 cancer patient with chronic asthma who could not wear the mask. And that a lot of these stores are imposing rules that don't take that into consideration. Apparently, some medical facilities and educational facilities are doing the same. So those suits have started. So at least as to those people being targeted who, for health reasons, cannot wear masks, and that can apply to people for anxiety, for other reasons, give kids, people with autism or on the spectrum. So the goal is to start establishing precedent to at least limit that part, the most problematic part of those mask mandates.
And you saw the story. It was a social media personality who was kicked off a plane and banned from flying. I think it was United. At the risk, I may have gotten the name wrong. I don't want to be sued for defamation. An airline. They were banned from flying on the airline because their 2-year-old daughter wouldn't put on a mask. It was on the Ben Shapiro show. Someone sent me the link. I mean,
unfortunately, right now, their airlines, even though there's a law that prohibits them, the courts have interpreted them as to not allow a lawsuit for violation of that law. So until that law changes, airlines are the ones that are exempt from all this. But everyone else can be sued for denying places of public accommodation for discriminating against people based on a disability. And in fact, they also thought that you had to carry your papers around with you. That's not the case. There's a HIPAA problem with that demand that was made. So we have started those suits to make sure at least those people are protected from the mask mandates. And my theory is you work from the outside in. You take the most extreme examples, the most absurd examples of these lockdowns, of these mask mandates, expose them, get the courts on your side about those, and then you can encroach further into recognizing the unreasonableness of a lot of these mandates and orders just in general.
All right, we got Viva. We need to know what the cigar is this week.
Oh, this one is H.R. Upman's cigar.
I know nothing about cigars, so that could be that could be a cigarillo for all I know. I think we did.
So, and then otherwise, I think we'll get to Biden immigration next week, see what the actual plan is. He's talked about it. I haven't seen the legislative details, just the discussion. But the big question with him is how many people is he trying to amnesty and how quickly? It looks like the talk was 11 million people 8 years from now. It looks more like 8 million people in 3 years and maybe 30 million over 20 years. Because of the way he's the whole key is the loopholes. How many family exception loopholes are there? Can you file for immigration even if you've already been deported and violated law before? Those are the keys. The devil is truly in the details when it comes to the consequences of immigration reform, but we'll know that more next week. To some of the locals questions from Lin 1995, is there a conflict with Nancy Pelosi setting up her own committee to investigate potentially her own conduct related to January 6th? Yes, there is.
Yes.
Yes, that's an easy answer. One-word answer. It's my favorite. My favorite phrase is always one word. It drives everybody crazy because they'll ask me something. I'll say, okay, true, yes, that's it. Second, but in this case, particularly apt. From roughly 40 cats. I guess that maybe that means they roughly have 40 cats. What do I think about the Republican National Committee's Election Integrity Commission? I think it's a fundraising crock. They've shown no commitment to meaningful election reform. So they're just wanting to hustle your cash one more time, like they did after the election. From question third from Thomas Jefferson. So he's back from the grave. About Project Veritas' suit against the New York Times. We'll cover that in the future when it has an update. And Crowder's suit against Facebook hasn't been filed yet. He talked about it being filed, but it's taken a while. So there's once it's filed, Viva will definitely have something on it, and then we'll discuss it.
And I was going to say, Thomas Jefferson has been brought back from the dead so he can be impeached.
Yes, exactly. That's right. Of course, he was a slave owner. So bring in George Washington, bring them all back. From Matt, IWB, Matt, KYT, on locals, what about lawsuits relating to critical race theory in the workplace? I'm working with a group of lawyers looking at those issues. To me, a lot of this seems like open racial discrimination. So you saw the lady that retired from that college or resigned from her college because of these kind of issues. And she's a liberal. It's people that we're seeing pushback in amongst the liberals of Europe who are like, this woke stuff sounds kind of insane. And so I think we'll see continued political and legal pushback, but we'll have more commentary on that once that's thought through.
I'm going to
And
bring
then
up
I think we
Jonathan.
answered the other questions that were asked, with the only exception being from Jordan 60, are there laws to remedy constitutional violations? There are for state actors. It's tough for federal actors. There's what's called Biden claims. Not Biden claims. That's a faux pas. The Freudian faux pas. Bivens claims. But they're limited, and there need to be better laws dealing with federal officers violating the law, in my view. But that's going to be a legislative remedy. And as to Australian Facebook, we'll probably have more commentary on that next week, relating to there's some new creative antitrust lawsuits being filed against Facebook all across the country. So we may talk about that context in which Facebook faces real legal exposure. But yeah, no doubt, censoring an entire country is a new step for Facebook.
No, and I had someone tell me on Twitter that it wasn't censorship because they were responding to regulations that would have forced them to pay money to act as click-through links. The problem was that I understand that's the rationale, but it is censorship when they're shutting down links that were actually not news links, just to either be sure or to flex their muscles, say, you want to make us pay, we'll make your entire country pay. So it's quite clearly censorship one way or the other. It just depends on what the motivation is and what the impetus is. Now, I wanted to bring the two best panda lawyers. Thank you, but that was not the chat I wanted to bring up. Someone had a fact check chat. Nerds, I think I lost it. It was a fact check on Texas. I lost it. Okay, whatever. I lost it. Let me just go bring some of these super chats before we leave. Can people bring suits against Biden for shutting off comments on White House YouTube videos, like how Trump was forced to unblock people over First Amendment?
I actually answered that. They can find that in the answers to the AMA questions that I do each week at vivabarneslaw.locals.com.
The one-liner, I suspect the answer is no. Access to information is not the right to speak to that information.
It depends. The short answer is it really depends on when they shut off those comments.
Okay. I hear the footsteps of the bell that's ticking. My company has mandated highly recommended vaccines for all employees. If you don't get one, you can't go onto the property in Connecticut, probably. How are employers able to mandate medical procedures?
It's going to depend on what the government gives them in terms of immunity and whether they require it as part of OSHA regulations. There's still supposed to be protections against emergency vaccines, which is what this is legally labeled as. Also, protections for religious exemptions and other health risks. And that's why that's going to be an ongoing legal issue, but it's probably why they're trying to censor and suppress any speech that raises questions about its safety or efficacy right now.
Yep. Okay, let's see this. We'll end it on this one. To overturn unconstitutional emergency laws, we need the right case with the right plaintiff and the right attorney. Robert Barnes, anything. Well,
that's what the mask mandate lawsuit is partially about, is finding the case that's the most egregious example with the most sympathetic plaintiff, with the most unsympathetic defendant, to show how this works, taking it to its logical aspects. What does this look like in its worst case situation or scenario, to try to start getting remedy that way? You take the worst example of what they're doing to try to push back all the way to what they're doing at the core.
Okay. And now Camila Vasquez says, I said this Viva by Jonathan. Fact check. The request was granted, but included a warning that they not exceed the amount of generation needed to restore power and keep Texas warm.
That may be right. There's disputes about precisely what took place. So there's different aspects about what the Biden administration did or didn't do, what conditions they did or didn't put on, the degree to which wind power was related or not. That's why it's going to be an open investigation. But because there probably was some money that shifted hands, some power that shifted hands at the expense of a lot of ordinary people on a massive scale in a state like Texas, it's got a lot of plaintiffs' lawyers in that state. You can expect to see a lot of litigation, and we'll see where it ultimately shakes up. But I think the Paxton Attorney General investigation and the legislative reaction will lead us to some, at least better information as to what happened and why.
All right. And now, before we leave it, Robert, everyone always likes good words of wisdom before they head into a fresh new week. What do you have for us?
So, I think that it's a good reminder of Bobby Kennedy's book, To Seek a Newer World, which comes from the poem, actually. Because he was a huge fan of all the English poets and the rest. He had a classical education back when we had real education in this country. And it's Alfred Lord Tennyson, which talks about the lights begin to twinkle from the rocks. The long day wanes. The slow moon climbs. The deep moans round with many voices. Come, my friends, 'tis not too late to seek a newer world. And that is part of it. It's a great poem. It's a great phrase. And it's a great reminder that you continue to fight for change, because that's the only way change happens, is by your action and fighting for it.
All right. And actually, I totally forgot, and this is not to take away your last words of inspiration. Next week, Rumble is launching live stream. So I think I might be the second creator to have access to live stream. It's in the beta stage, I think they call it, but we will be simultaneously streaming next week's stream. It won't have any impact on YouTube. I don't know how these things work. I get a code or a link, but we will be live streaming on Rumble next week as well. Apparently there will not be any live chat, but they're working on that as well. So that's the big news. So stay tuned for that, and we're going to see where that goes.
And for those who want to, I'll be doing a live chat in a few minutes on the vivabarneslaw.locals.com for members and subscribers after the show. Probably go about 30 minutes or so.
Okay. And you know what? So we'll end it there. Everybody, if you want to go, that's where the après party is. And yes, it is behind a paywall for supporters, but all of the videos, streams are going to be out here still. They're going to be on Rumble. It's just an extra way for people to support us. And for those who do, there's some perks, and that's just the nature of the business. Robert, thank you as always. Stick around for the proper goodbyes. Everybody, enjoy what's left of the weekend. Enjoy what's coming up in the week, and have faith. And, things will get to court and things might change. I hear something. Quick. Come say goodnight. He's coming. Don't fall down the stairs. He's coming. Okay, here we go. Just in time. What do you say? Good night. You smell like someone brushed your hair. No.
Daddy?
Yeah.
I was falling Pudge's sleep.
Oh, yeah. Okay, one of our dogs is falling asleep. So that's it. Everybody, enjoy the week, and we will see you next Sunday, unless we have a midweek stream, which maybe we'll do one of these days. But if there's big news, we'll do a midweek stream. Everybody, thank you for tuning in. See you